It appears to be so. So first of all, let me thank the organizers, and especially Marco Fabri and Daniela Cavallini for their kind invitation to participate to this experience, which is a very interesting one. And my contribution will be a brief presentation on the structure of the Court of Justice of the European Union decisions. The structure and the drafting of these decisions. Well, let me set at the outset some introductory remarks about the court in itself. The Court of Justice of the European Union is, as you might know, the sole judicial authority of the European Union. Is based in Luxembourg, and it must be distinguished from other supranational courts, such as the Hague Court, so the International Court of Justice, and the Strasbourg Court, the European Court of Human Rights. So today we will deal only with the Luxembourg Court, although in the end I will tackle also the ECHR decisions very briefly. The Court of Justice in itself, the Court of Justice of the European Union, consists of two courts. The Court of Justice, C, this is the letter that you should remind, and the General Court, T, like the French word tribunal. Each of these two courts is composed of a certain number of judges and advocate generals. For the purposes of today's presentation, it's only important to remember that judges sit in different formations, which are called chambers. The data relating to the chamber of a given decision is important because it is an indicator of the relevance of the case. So there are two courts composed of several chambers, and there are three types of cases before these two courts. Preliminary rulings, basically questions of interpretation of EU law raised by a national court. Direct actions asking for the annulment of an EU act, and appeals, which are action asking for the annulment of a general court's decision. So three types of cases before these two courts. Of course, as the appeals are only brought before the Court of Justice, this is self-evident. Two courts, three types of cases, and three types of judicial decision. We will only deal with the first two types, so judgments and orders. These are the only judicial decisions that are ruling in themselves, ruling made by a court. Final introductory remarks. It is important to remind that there is a specific language regime attached to the CJEU's decisions. The judgments delivered by the Court of Justice or the General Court are available in principle in all EU official languages, so 24 languages, on the day of the delivery of these judgments, whereas the orders are in principle only published in the language of the case and in French. What about the structure of the Court of Justice of the European Union decisions? Well, the text of the decisions appear as a document organized into parts, each with its own title and subtitles. There are, more particularly, three parts of the Court of Justice of the European Union decisions. The second and main of which is numbered and divided into sections and subsections. So these three parts are the cover page, the grounds, and the operative part of the decision. There's a little mistake there on the slide. It's the third part, of course, the last one. So let me start with the cover page. I'll just show you one example, which is a preliminary ruling judgment, a judgment of the Court of Justice delivered on a preliminary ruling, in order for you to understand where you can find all the relevant informations in the documents that are published by the court. So this is the cover page. As I said, three main parts of the Court of Justice decision. The first is the cover page. The cover page is relevant, I would say, is essential for the purpose of your hackathon, because it's where you can find all the relevant information regarding the case and its handling by the court. So first of all, number one, the type of decision. You remember that there are various types of decision: judgments, reason, order, opinions. There, where you can see one is the type of decision. So in this case, it's a judgment. It's a judgment delivered by the court, so one of the two jurisdictions of the Court of Justice of the European Union, and more particularly by the Grand Chamber of the court, one of the various chambers that compose the court. Remember, chambers are an important indicator of the importance of the case. Then there is the date of the decision, number 3, with a footnote indicating the language of the case. In this case, the language of the case is Croatian, as you can see, whereas the language of the document is indicated here, and it's English. Number 5, the keywords. So the summary of the issues that are discussed in the decision. 6, the case number. Remember, C stands for court, whereas T stands for general court. Number 7, the type of case. Here we are confronted with preliminary rulings. You see, requests for a preliminary ruling. And then at the bottom of the first of the cover page, you have the ECLI, the European Case Law Identifier. In this cover page, there is also the indication of the parties to the case. Number 9, in bold. Plus the representatives of these parties when we talk of direct actions and appeals. Here, it is a judgment on a preliminary ruling, so only the parties to the main proceedings are indicated. And final part of this cover page, number 10, all the steps of the procedure before the court. So you see, first of all, once more, the chamber delivering the judgment. So in this case, the Grand Chamber, the composition, the actual composition of the chambers, all the judges that were sitting, the indication of the judge rapporteur, of the advocate general, and of all the other procedural issues before the court. Whether a hearing has taken place, whether the advocate general is presenting his or her opinion, and whether observations were submitted before the court. So in the cover page, I stress one more these things, you'll find all the relevant information concerning both the case and its handling by the court. After the cover page, there is the second main part of the Court of Justice of the European Union decision, which is the most important one for substance, of course, because there you can find the grounds here. You see, there's a number 1, and before the first title, there are 2 or 1 preliminary points that are very relevant because it's where you can find the subject of the case. What is the subject of the court's decision? Then there is the first section of the second part of the court decision, which is the legal context. There you can find in order international law, EU law, and national law provisions, remembering that only the provisions that are referred to in the grounds of the decision are cited here. All and only the provisions that are quoted by the court are cited in the legal context section. Then there is a section on the factual background to the dispute, which is called for preliminary rulings like this one, the dispute in the main proceedings and the questions referred for a preliminary ruling. There you can find a summary of the facts and legal issues of the main proceedings before the national judge who's referring the questions to the court. And you can also find, see this point 24, the preliminary questions in themselves, as they were formulated by the referring court. You see here, these questions cited word by word. This is a preliminary ruling. Of course, the direct action and appeals are slightly different. The section is called background to the dispute, and there are information on the procedure before the general court, if applicable, and the court of justice. But the issues that dealt with in this section are the same: factual background to the dispute. There are possibly some sections on procedural issues, jurisdiction of the court, admissibility of the action, and so on and so forth, which are eventual. It is only possible that the judgment contains these sections, which is not the case for the third and main section in which the second part of the decision is divided, which is the one related to the substance of the decision. So under this title, consideration of the question referred, you'll find the substance of the grounds of the decision. In other words, here you'll find the answer to the questions raised by the national court, in the order in which they were formulated by the referring judge or in the order decided by the court. This is also important. The question is presented by the court, then there is a statement of the reason justifying a certain answer to the question, and then there is the answer in itself, which is formulated always in the same manner, as you can read here. In the light of all the foregoing considerations, the answer to the n question, to the first, to the second, a several number of questions, is that the provision X must be interpreted as. There is one subsection for each question or group of questions. This is, as I said at the beginning, a preliminary ruling. Direct action and appeals, decision on direct actions and appeals are slightly different, but similar in the sense that under the substantive part of the grounds of the decision, you'll find the arguments of the parties, starting with the appellant, and the finding of the court. So a statement of reason leading to the rejection or the upholding of the plea or of the ground of appeal. And then there are the costs, which is the fourth and last section of the grounds, followed by the third part of the ground, or the third part of the decision, which is the operative one. This bolded here. And in the operative part, of course, you'll find a list of answers to the various questions, so the various pleas in law, in the order in which the court answered the question or examined the ground, as they appear in the last point of each subsection of the second part of the judgment. It sounds very complicated, but really in order to understand how the decisions of the court are structured, it is important that you bear in mind this brief notes that I just gave to you. So remember, 3 parts: cover page, grounds, operative part. The cover page is numbered, and the grounds are numbered, and in the grounds you'll find, along with some procedural issues and the presentation of the legal and the factual background, you'll find the grounds, so the statement of reasons justifying the answer of the court, which is then properly formulated in the operative part, the last part of the decision. This applies to all the decisions delivered by the Court of Justice of the European Union, so both by the Court of Justice and the General Court, and with slight differences that I mentioned, applies to all types of cases dealt by the Court of Justice of the European Union, so preliminary rulings, direct actions, and appeals. Some brief notes on the drafting of the court's decision. Since the aim of your hackathon is to find common elements, I think it's important that I stress 2 brief notes on the drafting technique of the court. First of all, you have to bear in mind that the court uses a technical but specific language. Even if there are no preset formulas to answer the questions on the merits, there is nonetheless some recursiveness in the court's decision. The logical connectors between sentences and between points are always the same, and the way in which the sentences of the court's decision are worded is broadly similar. Plus, there are frequent citations of other courts' decisions. Second brief remark about citations. It is essential in order to compare courts' decision to understand, in my view, to understand how the court cites its own case law. There are 2 main ways of citation. The first one is when the court is placing the references of the cited decision in brackets, adding this wording, see to that effect, judgment of, or see by analogy, judgment of. This means that the citation is not literal. So you'll find a point of the grounds. At the end of the point, there are brackets. In brackets, there is a reference to a court's decision, but before the reference to the judgment, there is see to that effect or see by analogy. This means that the text that is quoted is not literally quoted. There are modifications to the text that is quoted. Some changes have been made, more or less important. On the contrary, where you find at the end of a point of the grounds of the decision, of a numbered point, brackets in which there is only the reference to the judgment of 10 September 2024, etc., etc., this means that we are confronted with a literal quotation, a literal quote of another judgment, so a copy-paste of a point of another judgment. Final remark, very, very briefly. It is, apart from what I said on the decision of the court itself, it is very important to remember that the structure of the court's decision, which is in itself very complex and different from a case to another, as I said, is not comparable as such to those of other supranational courts. It is very different to start with from if you compare it with the International Court of Justice decision. The decisions of the International Court of Justice, first of all, the title of the cases is based on the content and not on the parties. There are no procedural details on the handling of the case in the International Court of Justice decision. You'll find number points, but no subtitles. And they are more discursive judgments. They are organized according to the topics discussed by the ICJ. So two completely uncomparable judicial decisions. As for the European Court of Human Rights judgment, they are most similar to the Court of Justice of the European Union ones, but there are still important differences in the structure of the judgment, which are, of course, relevant if you have to compare them. The cover page is broadly similar, but the grounds are structured in a different way. First of all, facts before legal background. The reasoning of the court is organized by type of alleged violation of the convention, which means that the structure is more similar to that of direct actions before the Court of Justice rather than the one that applies to preliminary rulings. And there is an important difference, which is the section dedicated to the just satisfaction, as the court call it, meaning the damage for the violations of the convention. This is peculiar to the CHR decisions and does not apply to the court ones. And then the operative part is different because there you'll find the statement of either a violation, defining of either a violation or a non-violation of a given ECHR provision plus the damages awarded. With that, I conclude and I thank you for your attention.